Hi, it's Jeremy Long, and this is my video for EDL 850 on tort law. What is tort? According to Essex, a tort is an actionable or civil wrong committed against one person by another. Now, in terms of the school, a tort liability means that if a student is injured physically or mentally on the school property or because of the school, they could be held responsible. There's two types of torts. Intentional tort is a wanton or willful act. And unintentional is a failure in duty or care that is negligent but did not involve a deliberate act to harm. So I went through 5 cases as required by the module. The first case that I looked at was Johnson versus School District of Millard. And this case took place in Nebraska and was brought to the Nebraska Supreme Court in 1998. Now the facts are that the teacher facilitated the playing of this game during music class called London Bridge, in which this young student, was swung by 2 classmates. The classmates were reckless and threw him into a bookcase. The teacher didn't witness it because she had her back to the class and was writing on the board, and he ended up with 50 stitches, and his parents sued the school in his name. So the court's ruling in this case was that, first off, it went to a trial court, and then it ended up in the Supreme Court because of an appeal. The court ruled that the teacher was negligent in not supervising students in the early portion of the game, and the kid was the first kid to play the game or be swung. The district argued that the teacher was held to an unreasonable standard of care, but the court said that even though the teacher maybe should not be expected to supervise all students at all times, in this case it was foreseeable that the game could have caused injury to the student, and therefore she needed to be giving supervision at that point in time. So the teacher was negligent, and her negligence was the impending cause of the student's injury, which resulted in a ruling for the plaintiff. And if this happened in my school, there would be required trainings, a lot of them most likely, regarding negligence, of how this applies to in loco parentis and the standard of care, which you find in Essex. So I think that tort training in general is a good exercise for being proactive. A few years ago, we had an attorney come into our school, discuss some legal responsibilities with our staff. And when it comes to professional ethics, I find this one to be pretty straightforward. It's a teacher's moral and professional duty to monitor the actions of the students in the situations that could be dangerous. In this case, the teacher was she was negligent. Now, in case 2, Orson Munn, or Munn versus Hotchkiss School. I'll get to the right slide here. Munn was a 15-year-old girl who contracted a tick-borne illness on a school trip to China. Now, this was a public school, and she contracted the illness, which was serious and incurable. It was treatable, and the jury ended up in the original trial case awarding her family and her $41.5 million as compensation. And this was taken to appeals court and eventually wound up in the Connecticut Supreme Court finally in 2017. It began in 2007, and the facts were that the school had not warned students of the possibility of a serious insect-borne disease, and that was problematic, and the court's ruling showed that the school did have a duty to warn the students about foreseeable dangers on the trip, and even though they couldn't be an insurer of safety, it was definitely foreseeable that a student on a trip climbing a mountain in China could have received a insect-borne disease, and she did. The bottom line was that the sponsor and the school failed to warn parents properly, and that's why the court ruled in the plaintiff's case. Now, my school doesn't take international trips, but this case is applicable because I'm an FFA advisor. I take students on many trips throughout the year, including those that go out of state, and we have a general trip release form that's approved by the Kansas Association of School Boards for our activities, but we probably should be a little bit more rigorous in our review of this waiver, and if we need to, on an individual basis, take a look at the trip and what we're telling parents. We need to be proactive regarding safety precautions and general procedures on our trips. Now, I have a lot of experience on extended trips with students, as I said, so I have a little bit of a unique insight. I'd recommend at least 2 administrators review all materials that will be given to parents and students regarding safety. Now, this is a difficult case. It's hard for me to believe that the school wasn't concerned with safety on a trip to China. However, the sponsor had a severe lapse in judgment. She actually allowed the students to hike down a mountain through like dirt trails and through underbrush without supervision and without insect repellent. They actually said in the case that she left her bug spray on the bus. So obviously this was problematic. Case number 3. In case 3, Hoyam versus Manhattan Beach City School District, there was a young man, 10-year-old boy in 1978, who he left school before the end of scheduled classes during summer school, and he ran into a public intersection and was struck by a motorcycle, resulting in very serious injuries. Now, the school claimed that they could not be responsible for an accident that did not occur on school grounds, and actually this case was dismissed at a lower level court, but it was appealed by the plaintiff, and it was eventually brought to the California Supreme Court, and they ruled that the case was unnecessarily dismissed. It eventually went back to the district court, and they ruled in favor of the young man and being represented by his family. So the school failed to exercise ordinary care to enforce its rule that students were not to leave school grounds before school had ended. The injury to the student was a direct result of a failure by the school, is what the court found, and the case was allowed to be tried in a trial case, as I mentioned before. So the bottom line here is that a school must monitor student activities. The precedent that if a student breaks school policy by leaving the school, even without the knowledge of the school, and is injured, the school is liable. Well, that seems difficult for us to grasp maybe at first. However, that student is in the care of the school during the time they're at school. So we can't lock students inside buildings due to fire codes, these types of things. How do we prevent it? Well, we have to be aware of our students and take hourly attendance. This is always harped on by administrators, we know. And that's not enough, though. We got to monitor exits during passing periods. We have to be aware of, at-risk students, risk to run. We have to use cameras to monitor school grounds. And it's probably a good idea to have a school resource officer posted near areas of foreseeable danger to students. I don't know if we need full-time crossing guards, whatever, but we have to prevent this type of thing from happening. And it's easy to say that we can't prevent it, but just because students have their own free will, they're going to run off. Well, this excuse isn't going to work in the court of law, nor to a parent whose student's been injured. So that's the reasoning behind this. Now, case 4 is Peterson versus Baker. In this case, a high school student arrived late to class. He and a friend were talking in the back of the classroom. The teacher was angry, asked this kid's friend to leave, Peterson's friend. He thought that the teacher was speaking to him, so he went to leave, but the teacher told him to sit back down. He refused this and attempted to leave, in which case the teacher placed her arm across the door frame to the classroom. The kid initiated physical contact with the teacher, and as he reached for the doorknob, the teacher grabbed his neck. That was the report. So the kid testified that the teacher tried to choke him, while the teacher said, "No, I feared that the kid was going to strike me, so I put my hand out to force him away from me." The kid ended up having bruises and scratches on his neck, and he came back and made the claim of battery. And this was obviously a difficult case. So the teacher, in the end, was not found guilty of any wrongdoing due to several factors, and they were this. The teacher's use of force was not excessive, the court found. They also found that the student was being disruptive beforehand and initiated physical contact, which justified some corporal punishment from the teacher, and also she was warranted in her fear that Peterson was going to strike her. On this note, the teacher would have been or was granted official immunity in carrying out her professional duties, and so that you can read about that, and we read about that in Essex, and I found that interesting. In most of these cases, immunity would be granted to the school official and to the school in some cases. So evaluation in this, interestingly enough, a case like this happened in our school. The school administration and the Board of Ed supported the school employee because there were multiple credible witnesses that supported the employee's testimony. Now, no charges were filed, and we had a special faculty meeting to discuss the incident with our administration. So that's what I would foresee happening if something like that happened again. Now, proactive measures that we can take include educating staff on the actions that they can and cannot take in scenarios such as this one. The teacher's behavior in this case does apply to professional ethics, because as a teacher, she had the right and the duty to control her classroom. She also had a right to protect herself from harm, and the court ruled so. Now in case 5, we find Wallace v. Bryant School District, and in this one, a female junior high student ended up suing a school because she was told to go inside an isolated room for disciplinary action. She was disrupting class. She'd had several meetings with her parent and administrator and the teacher before about this. The room that she was asked to go to was a 10 by 14 foot room. It had light controls inside the room, and it could not be locked from the outside. Now, these are key points for later on in the case. Wallace, the girl, was not forced to enter the room and was able to work on her homework while she was in there, and this happened 3 separate times as she was being disruptive to class. Wallace sued the school on claims of false imprisonment, negligent infliction of emotional distress, negligence, and deprivations of constitutional rights. So let's talk a little bit about the court's ruling here. The court ruled in favor of the school district on each claim based on the fact that of false imprisonment, there was no false imprisonment because she was not forced to enter the room and she could have refused to enter. There was no emotional distress because there was no willful and wantonly caused distress in the case. There was no evidence of this. There was no negligence. There was no constitutional violation because the evidence provided proved that the room in which Wallace was asked to stay was not prison-like in any way. Now, this case was obviously an open and shut case in favor of the school. However, it was interesting to me because it provides some interesting insight into the reality of school tort law. Even the most unwarranted claims can seriously damage the reputation of school district. As teachers, we know this. It appears that Wallace was unsupervised while she was in the room, and this could have become maybe a serious issue had another event such as an injury occurred. So here again, if a situation like this took place in my school, I foresee a reaffirmation or creation of policy that no student should be left unsupervised in a room by themselves, which is already our policy. The student had evidently documented the discipline issues. The school had evidently documented discipline issues with the student before. Not only is this important from a professional standpoint, but it's also the first step in justifying actions of teachers and schools. Staff needs to be well versed in the methods for proper documentation, reporting, procedural steps to follow up on situations involving students, and we can even tie back into FERPA on this. So ethically, I really see a responsibility for professionals to recognize what is best for all students. In this case, sending a student to an isolated room was not harmful to the student, and the school was found, was absolved of all claims. However, referring her to the office maybe would have been the better thing to do in that situation. So that's my 5 cases on tort law in schools.